to rent checks. So what's changed and what hasn't? Since its introduction in 2016, the UK's right to rent scheme has required landlords in England to verify that their tenants have the legal right to live in the country. While the core principles of the scheme remain the same, recent developments, particularly digital options and changes following Brexit, have introduced new considerations for landlords. So, understanding both what has changed and what has stayed consistent is crucial for anyone letting out property. So, understanding right to rent checks. Right to rent checks are a legal requirement for landlords before they allow someone to rent residential property. The purpose of these checks is to prevent individuals without lawful immigration status from living in rented housing. Landlords who fail to comply with this requirement risk civil penalties, including fines and, in some cases, criminal liability. The checks must be completed before the tenancy begins. Although the process may seem administrative, it is fundamentally about compliance with immigration law rather than screening tenants based on their nationality or even their background. So, firstly, let's look at what hasn't changed. The most significant constant is the legal obligation itself. Landlords are still required to verify every adult tenant's right to rent in the UK, and this verification must be consistent for all tenants. This ensures that landlords are protected from penalties and that tenants are treated fairly. The underlying purpose of the checks has also remained unchanged. Right to rent checks are not intended to discriminate against tenants, but rather to confirm that they have lawful permission to reside in the UK. Conducting checks fairly and consistently remains an essential requirement of the scheme. So, let's look at what has changed. One of the most notable changes in recent years is the formal recognition of digital right to rent checks. Previously, landlords relied primarily on physical inspection of original documents, such as passports or biometric residence permits. Now the Home Office allows tenants to provide a share code linked to their digital immigration status. This digital verification option makes the process faster, safer and more convenient, particularly when tenants are abroad or unable to present original documents in person. Brexit has also altered the landscape for EU and EEA nationals. With the end of freedom movement, EU citizens without settled or pre-settled status no longer automatically have the right to rent. They must now provide evidence of a valid visa or residence status, meaning landlords need to be more vigilant in verifying immigration status for this group of tenants. Additionally, right to rent checks now intersects more closely with broader changes to UK immigration law. Various visa categories, indefinite leave to remain and other status types have emerged, and landlords must stay informed about which statuses confer a legal right to rent. Maintaining compliance and fairness. Despite these changes, the rules around discrimination remain stringent. Landlords must carry out checks equally for all prospective tenants following the Home Office approved process. Rejecting tenants based on unfamiliar documents or nationality is unlawful. Consistency in procedure is essential, both to protect tenants' rights and to shield landlords from potential legal consequences. Practical guidance for landlords. To navigate these changes effectively, landlords should rely on official Home Office guidance and approved processes. Digital checks are recommended where possible as they are efficient and reduce errors. Maintaining clear records of all checks, whether digital or physical, is crucial. Records should be retained for at least 1 year after the tenancy ends. Landlords should also regularly update their knowledge of immigration rules and right to rent guidance to remain compliant. The right to rent scheme continues to be a fundamental responsibility for landlords in England. While the core requirement and purpose have not changed, digital verification options, Brexit-related adjustments and evolving immigration categories have introduced new considerations. By understanding these changes and maintaining consistent, compliant procedures, landlords can protect themselves from penalties, ensure fair treatment of tenants, and operate confidently in an increasingly complex regulatory environment.